Now, Edward Kruk, his origins are from studying in Edinburgh, but he is the Emeritus Professor of Social Work at the British Columbia University in Canada. He's been over here for holiday, but because he is involved not only with that in his academic life and in publishing things like this book, which was called the Equal Parent Presumption, which is one of his publications, but he's also the president of the International Council of Shared Parenting, which is an organization we are a member of. It's now a worldwide organization holding conferences and research and publishing material. They had a very good conference in Athens earlier on this year. But anyway, so Edward is going to address us on this topic that we have for this evening. And what I'm going to do is just hand over to him, and he's going to ask the question, why courts at all? So, Edward.
I just advanced. Okay.
And we're recording all right?
Yeah. Okay, great. Well, thank you all for coming out on such a lovely evening. And it's nice to see a good number of people showing up. As Ian mentioned, I'm a recently retired professor of social work at the University of British Columbia in Vancouver, Canada, where I still have a research appointment, and I'm still working in the field of parenting after separation. It's my main focus, but also taught at the university for over 30 years, child and family policy and practice. But I guess more importantly, I would say the University of Edinburgh is my alma mater. I came here in 1985 after working as a social worker in Canada, in Toronto, with children and families as a school social worker. And I'm now back after really a long period of time away from the city. So it's great to see that the festival is alive as ever, and the city is more alive than ever. It's really changed markedly in these kind of intervening 30 to 40 years since I was here. But I was here in 1985 to 1989. Where I began my studies after working as a child protection worker, school social worker, also for a number of years. It's the place where I first began to research the whole question of family transition attendant to divorce and separation. When I embarked on a study on the impact of divorce on non-custodial fathers, at that time in 1985, there was a lot of attention being paid to this phenomenon of deadbeat dads, so-called. There was a massive study in North America by a sociologist by the name of Frank Furstenberg, who discovered that fully 50% of non-custodial dads lose all contact with their children after separation. It was just assumed that, these were fathers who were pretty much on the periphery of their children's lives to begin with, and just after separation, just lost all interest and were footloose and fancy-free and quite happy to disengage from their children. But I really wanted to know why that was the case. In fact, nobody had actually asked fathers themselves. There was a lot of judgment and stereotyping of fathers, but no one had actually asked fathers themselves why it is that so many were kind of dropping out of their children's lives. So that was the main focus of my research. I did a study of 100 fathers, very in-depth, where 50 fathers from Scotland, 50 from Canada, 50 who were as non-custodial fathers still in contact with their kids, and 50% of who had lost all contact. And the results were quite surprising and completely contrary to the dominant stereotype at the time. I found that fathers were really suffering a major grief reaction directly connected to the absence of their children in their lives, the loss of the father role, and the constraints of visiting their children as opposed to having any kind of meaningful parental parent-child interaction with their children. Totally different than the sort of dad phenomenon. Interestingly, I found that fathers who were previously somewhat on the periphery of their kids' lives, the ones where mothers had been the primary caregivers, these were fathers who are actually able to maintain, more likely to be able to maintain contact, surprisingly. They weren't the ones who were losing contact. They were fine with every fortnight visits on a weekend. And actually they found that within, those, even that limited contact, that often they were closer to their children than they'd ever been because they took sole responsibility for their kids, even if it was 2 nights out of 14 kind of thing. But it was the previously highly attached, highly involved fathers who suffered the most and were most at risk of losing contact. And it was because, well, the absence of their children and just, their own psychological response to loss of that role. Many became quite depressed. They found the legal system, they were really pushing the legal system to gain more access to their children, encountering all kinds of constraints along the way, wanting to be as meaningfully attached and involved with their children after separation and were unable to do so. So it was a combination of structural constraints where they were relegated to the sidelines of their kids' lives, but also their own psychological reaction to the loss of their children that kind of resulted in that state of affairs. So actually, this was the first study I found of parental alienation. It's rarely cited. I published that study, by the way, as a book and several articles in professional journals. This discontinuity between pre and post separation father-child relationships was a bit surprising, and a lot of journals published that, and subsequent studies found similar results, that often the most attached fathers are the most vulnerable and at risk, and their children, of course, are at risk. So yeah, it was published, but I didn't use the term parental alienation because it had not yet been coined. I guess around the same time Richard Gardner was beginning to study parental alienation, and a year or two after coined the term parental alienation, but I referred to it as involuntary paternal disengagement. Since then, I've expanded my studies of the impact of divorce on family members. I've also studied non-custodial mothers or non-resident mothers and found similar kinds of reactions on the part of mothers, but they experience so much more stigma because they're judged to be, well, okay, it's one thing for a father to be, to lose contact with his children, but quite another thing for mothers to do so, and often they're judged quite harshly. The stigma and shaming that they experience is quite different to what fathers endure, but still, the responses are very similar. I've looked at grandparent alienation as well, and that was a study I did 30 years ago and then replicated, and I'm currently now replicating. I found, I guess it was 25 years ago that I did my first study on grandparent alienation. I found grandparents who were the most at risk were the parents of, were paternal grandparents, where mothers were granted custody, and when the father lost contact, then the paternal grandparents were at risk. Now I'm finding that I'm studying grandparents who've never met their grandchildren, who've just heard that they have grandchildren, and they experience kind of a particularly acute sense of loss there, because these are grandparents who were alienated from their own children. And now these alienated children of theirs are having their own children, and the grandparents are also alienated from their grandchildren. So they're experiencing kind of a double loss in there. They're a group that are quite isolated. Not too many people know about them. Again, I think this is the first study that's been undertaken of grandparents who've never met their grandchildren, and I'm currently involved in that. I've also done a lot of research on family mediation and the different working methods of family mediators and the effectiveness of mediation in regard to resolving parenting disputes after separation. I've done sort of survey research of mediators, and I've done more in-depth kind of qualitative research looking at how mediators handle difficult situations like power imbalances and abuse and family violence sort of concerns, and how they resolve unresolved marital attachment, how they deal with that. And more recently, my work is kind of mainly focused on child custody determination. I've done a lot of in-depth research on shared parenting as a more viable approach to sort of helping parents adjust to the consequences of divorce and kind of a living arrangement for children. And parental alienation is sort of an area of study for me today. So the focus of my presentation today will be on shared parenting as a more viable living arrangement to traditional custody arrangements. So what I'll be talking about then is the establishment of shared parental responsibility as a foundation for family, a new foundation for family law, and the scientific evidence for shared parenting, and a proposal for legislative reform in the direction of shared parenting. In the first part of my talk, I've got a kind of 5 topics here. I'll just quickly go over. I'll be talking about this sort of a new idea of how we might address the so-called best interests of the child from the perspective of the child. I'll secondly review the scientific evidence in favor of shared parenting. There have been so many studies over the last 20 years comparing outcomes for children and families in shared parenting versus traditional sole custody homes. I'll look at what other countries have done in regard to establishing shared parenting as a foundation for family law. I'll present to you kind of a template of what I think might work best in the Scottish context, and then I'll just end the presentation with a discussion of therapeutic family mediation focused on the development of shared parenting plans. Right. So a few words about the title of my talk, Why Courts at All? It's a bit provocative title. During my time in Edinburgh, I worked closely with and benefited from the wisdom of a number of scholars, child and family practitioners, legal and mental health practitioners, and activists. And I'll just mention 2 people. First is Sandy Rayburn, who was at the helm of Scottish Families Need Fathers, which was the predecessor to Shared Parenting Scotland. Dr. Rayburn, and also Dr. Martin Richards from the psychology department of the University of Cambridge. Now, Dr. Richards worked closely with Jackie Burgoyne, who was also a psychology professor and the lead author of a seminal book, Divorce Matters, which was published way back in 1987. Now, as far back as the mid to late 1980s, each of these prominent scholars and activists were vocal proponents for the establishment of physical joint custody as the foundation of family law. And perhaps the boldest statement made at that time was the famous quote by Dr. Burgoyne, Jacqueline Burgoyne, "Why do we need courts at all? If joint custody is established as a presumption, why courts at all?" she asked in the book. And that question really has never been answered. It's considered heresy to speak in those terms today. We've really not moved forward with that one. And yet it was Aristotle who said that the best laws are those that limit judicial discretion. And nowhere is this more pertinent, I would say, than the field of family law, in family law, the indeterminate, vague, and ambiguous standard of the best interest of the child gives judges unfettered discretion to decide what's best for children based on their own biases and stereotypes in an arena in which they have no expertise, really, the very delicate realm of child development and family dynamics. And it was Hillary Clinton, then Hillary Rodham, herself a family lawyer at the time, who concluded, quote, "The best interest of the child is just an empty vessel into which adult prejudices are poured." End quote. Now, I'm not saying that there's no role for the courts to play in the determination of children's living arrangements after parental separation, but it should be restricted to cases where children are in need of protection as a result of the presence of established family violence and child abuse. And also in kind of financial determination of financial child support and division of property after divorce. But in all other cases, in the case of parenting after separation, the justice system should allow the space and possibility for mental health workers, such as family therapists and mediators, to assist families to resolve their conflicts regarding parenting after separation. Now, I'd suggest to you that a truly enlightened approach to the legal determination of parenting after divorce encompasses an evidence-based best interest of the child from the perspective of the child standard, and what I call a parental responsibility to children's needs approach. By this, I mean that the concept best interest of the child today is usually based on the idiosyncratic assumptions of adults. Rarely do we use a child-focused approach to establish what's in the best interest of the child. This idea of the best interest of the child from the perspective of the child standard is more of an evidence-based approach based on research on understanding the best interests of children based upon what children themselves identify in research studies as most important to them. I'm talking now not about young children being the subjects of research, but rather young adult children of divorce reflecting on their lives growing up in separated families. And we have quite a large body of research, particularly from the United States, from this perspective. And in regard to this other concept of parental responsibility to children's needs, if there's one point I would make today, it's this. It's the responsibility of social institutions, such as the courts, to support parents in the fulfillment of their parental responsibilities, not undermine them as at present. So parents are responsible to fulfill their responsibilities to their children's needs. For every need of a child, there's a responsibility that our parents have, and that social institutions need to support parents in the fulfillment of those responsibilities to their children's needs. In regard to courts, for example, their role is to serve parents in regard to supporting them to ensure that they exercise their responsibilities to their children's needs as much as possible, to ensure that they have the necessary supports to be able to address their children's needs. When they are given a voice, children are very clear, very vocal, and very clear about what their needs and best interests are. The two key factors in children's adjustment to divorce are, first of all, the maintenance of meaningful relationships with both of their parents. And there's a very clear linear relationship between the amount of shared parenting time and good outcomes for children, with children spending roughly equal time with each of their parents being the ideal. That's one factor that children consistently identify as most important to them and in their best interest. The second factor is being shielded from ongoing parental conflict and family violence. The safety of children is the paramount consideration in situations of family violence and child abuse. It's interesting that we encourage shared parenting as the norm. We'd like to see that being established as the norm in two-parent families. We see that to be in the best interest of children, but we seem to be reluctant to do so for children of separated parents. Continuity of relationships is also extremely important for children. If parents share the care before separation, they should do so after. There should be no barriers in their way in that regard. So I mentioned there are over 100 research studies over the past 2 decades comparing child and family outcomes in shared versus sole custody arrangements. We have clear evidence of shared parenting as in children's best interests, including in high conflict cases. And that runs counter to what many family practitioners, policymakers, and legislators have assumed. So rather than going through the main findings of these 100 studies, I'd like to focus on 4 key findings and 16 themes that have emerged from the scientific literature that together make a very strong case for the establishment of shared parenting as the foundation of family law. The 4 key findings, I'll just go through them very quickly. Most children of divorce want equal time with their parents and consider shared parenting to be in their best interests. The same applies for parents when you ask children and parents directly. Secondly, not only do children of divorce want equal time, but it's the best arrangement as far as their adjustment to divorce is concerned. The same applies to parents, and I'll say a little more about this in a moment. Thirdly, shared parenting reduces parental conflict and prevents family violence. Parental conflict decreases over time in shared parenting arrangements, but it increases in sole custody arrangements. Parental cooperation increases with shared parenting, decreases with sole custody. And finally, in most Western countries today, working mothers and fathers in 2-parent families now share the care for children. We've seen a marked, sort of this move toward shared care as the norm over the past couple of decades. And so shared parenting is now pretty much the standard arrangement in 2-parent families. Now, most of the 100 studies I mentioned have compared child and parent outcomes in sole versus shared care arrangements with a very wide range of findings. And in a recent article in the American Journal of Family Therapy, I grouped these findings under 16 main themes. And I think each of these findings, each of these 16 arguments, you could say, in support of shared parenting, I think each of them is kind of good enough reason to establish shared parenting as the foundation of family law, but together, it's difficult to argue against shared parenting. And the arguments are as follows. I'll go very quickly through this. First of all, shared parenting preserves children's relationships with both parents. We know that the removal of a primary parent threatens children's emotional and physical security. We know that a large proportion of previously highly involved non-custodial parents lose contact with their children. Father absence research especially is large and robust, to the point that researchers have concluded that father absence causes poor child outcomes. It's not just associated with poor outcomes, it actually is a causal factor, including delinquency and youth crime, poor academic performance, homelessness, abuse, depression, suicide, behavior problems, substance abuse, promiscuity, and teen pregnancy. Large body of research in that area. There's also a large body of research that shows that children in shared parenting have significantly higher levels of life satisfaction and contentment, enjoy more positive relationships with their parents. In fact, 3/4 of children in separated shared parenting families rank their level of life satisfaction as equal to or higher than children in 2-parent families. And several analyses have found that shared parenting is associated with much better outcomes for children and parents on all general and divorce-specific measures. And interestingly, and this comes from studies in the United States, children's highest level of emotional security is at 50% time levels with each of their parents. The closer you get to a 50-50 division, the better the outcome for children. Secondly, second argument is shared parenting preserves parents' relationships with their children, and parental adjustment is enhanced by shared parenting. The highest levels of depression among adults occur among those who have a child under age 18 with whom they're not living or actively involved. These parents report isolation, loss of employment, inability to form or sustain new relationships, shame, stigma, self-blame, learned helplessness, and hopelessness. In fact, a suicide epidemic, that's the term used by one researcher, has been identified among divorced fathers without custody. I mentioned already, thirdly, that shared parenting decreases parental conflict and prevents family violence, whereas sole custody exacerbates conflict and puts parents and children at risk of first-time family violence. Fully 50% of first-time family violence actually occurs during and after the separation transition period within the context of adversarial divorce. Not only does shared parenting reduce parental conflict, but it can ameliorate the harmful effects of high conflict. A warm relationship with both parents is a protective factor for children in high conflict families. The benefits of equal and shared parenting on children's well-being exist independent of parental conflict. Limiting parental time where there is parental conflict makes children doubly vulnerable. And I'm talking about parental conflict, not violence. Fourthly, shared parenting reflects children's preferences and views about their needs and best interests. Children strongly favor shared parenting in all the studies that have directly asked young adult children of divorce about their experiences. And children who have shared parenting arrangements have the best relations with each of their parents after separation. Fifthly, shared parenting reflects parents' preferences and views about their children's needs and best interests. As public opinion polls report that shared parenting is favored by about 80% of parents, with slightly higher percentage of women favoring a legal presumption than men. Sixth, shared parenting reflects child caregiving arrangements before divorce. With the gender convergence of child care roles, shared parenting has emerged as the norm in two-parent families, as I mentioned. So shared parenting most closely reflects existing arrangements before separation. And attachment theory also tells us that children form primary attachment bonds with both parents. Seventh, as shared parenting enhances the quality of parent-child relationships. Parents need ample time with their children to create and maintain relationships of quality. Quality, or rather quantity, is necessary for quality relationships. And high quality relationships between parents and children aren't possible without sufficient routine time to develop and sustain a relationship. Eighth, shared parenting reduces litigation. It removes child custody from the adversarial arena. It also decreases the parental focus on mathematizing time, which is this idea that parents are forever haggling over minute bits of time, how much, a custodial parent may want the other parent to have less time, the non-custodial parent wants more time, and there's kind of constant haggling. If it's equal time, then there's that decrease on mathematizing time. Moving on, a ninth argument in favor of shared parenting is that shared parenting provides an incentive for interparental cooperation, negotiation, mediation, and the development of parenting plans. It provides an incentive for the uptake of mediation and family counseling and support services. And all the other programs, therapeutic family mediation, parent education programs, parenting coordination in high conflict situations. And in those jurisdictions where shared parenting has been legislated, increased use of family support services has resulted in parents being able to resolve their differences without the use of legal services with respect to parenting arrangements. Number 10, shared parenting provides a clear and consistent guideline for judicial decision-making. It limits judicial discretion, enhances predictability of outcome, reduces litigation and hostility, and eliminates the need for courts to adjudicate between two perfectly fit and loving parents, or to remove one parent as a primary caregiver. Shared parenting reduces the risk and incidence of parental alienation, which is trauma writ large for children, as children are robbed of their parents' care and nurture, as well as that of the extended family. This is now, parental alienation is now recognized as a form of emotional child abuse and family violence. Shared parenting allows children to continue to maintain meaningful relationships with both parents, and they're thereby less susceptible to the toxic influence of an alienating parent. At the same time, with shared parenting, neither parent is threatened by the potential loss of their relationship with their children and less likely to denigrate and alienate the other parent. Number 12, shared parenting enables enforcement of parenting orders, so parents are more likely to abide by a shared parenting order. Sole custody orders have presented a law enforcement nightmare, with non-custodial parents vying for more time while custodial parents attempt to limit the time. Access denial is commonplace in sole custody arrangements, as are non-custodial parents not complying because they perceive sole custody as unequal and unfair. Ranking of parents fuels conflict. 13th point is that shared parenting addresses social justice imperatives regarding protection of children's rights, because shared parenting ensures the same legal protection of parent-child relationships for children of divorce as for other children. Only an unfit or abusive parent can be removed from the life of a child, rather than using a different standard, the kind of best interest of the child standard. Apply the same standard for separated children of separated parents as two-parent families, the child in need of protection standard. Shared parenting addresses social justice imperatives regarding parental authority, autonomy, equality, rights, and responsibilities. It avoids having the rights of one parent being privileged over the other, and affirms the equality of parents as primary caregivers as equally important in their children's lives. And finally, the sole custody model is not empirically supported. There's abundant evidence of the failure of that model. And finally, rebuttable legal presumption of shared parenting is empirically supported. So I'd like to move on and discuss options for a legal presumption of shared parenting in line with current scientific and legal opinion. This includes the European Council's recommendation that member states adopt shared parenting as the foundation of family law, and conclusions of associations like the International Council on Shared Parenting, which is an association which disseminates and advances scientific knowledge on the best interests of children whose parents are living apart, and to formulate evidence-based recommendations about the legal, judicial, and practical implementation of shared parenting. So when it comes to post-divorce living arrangements, I just quickly suggest that there are 4 key considerations for professionals in the legal, judicial, and mental health fields working with families when it comes to the issue of parenting after separation. These are 4 factors to consider. First of all, parents' desires and plans. Parents are most knowledgeable about children's needs and interests. So when parents are in dispute over parenting arrangement, it's important to know parents' desires regarding individual parenting plans. Secondly, it's a key factor is parents' relationship history with their children, the time each parent is invested in caregiving, how involved and available is each parent and attuned to their children's needs. Thirdly, children's needs for both parents actively involved in their lives, and fourthly, children's need to be shielded from family violence and child abuse. These are factors that legislators and legal decision makers should consider when thinking about child custody determination. Now, around the globe, there are a number of alternative approaches to establishing shared parenting as the foundation of family law. I don't think I actually have the time to go through them all. So I'm going to skip this part and go right into what I would suggest is kind of an ideal, sort of put out what I think might be a template for the establishment of shared parenting and family law in the Scottish context. So a four-pillar framework for a legal presumption of shared parenting in disputed cases. And the four pillars of shared parenting law would be as follows. First of all, family law reform, a rebuttable legal presumption of shared parenting. Secondly, the treatment pillar, which is the establishment of support services being in place for parents to allow them to implement a shared parenting plan, things like divorce education, family mediation, and intervention in high conflict cases. Then there's the prevention pillar, where the focus is on shared parenting public education, and finally enforcement of shared parenting orders by the judiciary. So looking at each of these pillars, the first pillar of family law reform would be the establishment of a legal shared parenting presumption in law, and what would that look like? So looking at what other jurisdictions have done, I would suggest perhaps consideration of four stages in establishing shared parenting as the foundation of family law. The first stage would be a legal requirement for a shared parenting plan, where parents are expected to develop a detailed co-parenting plan before any hearing is held on the matter of parenting after divorce. The role of the court would be to legally sanction the negotiation plan. The problem with just leaving things there is that many parents, despite a legal expectation to do so, may not be able to cooperate to the degree necessary to actually negotiate a plan. The second stage would be the application of the so-called approximation rule, which is present in some of the US states, when parents can't agree on a co-parenting plan. When they can't agree on a plan, the approximation rule would take effect, a legal presumption that the amount of time children spend with each parent is in proportion to the relative amount of time each parent devoted to childcare before the separation to ensure continuity. The Achilles heel of this part of this form of legislation, which again exists in several US states, is that parents often dispute the relative amount of childcare time that each of them is devoting. So where both parents claim to have been primary caregivers before divorce, the third stage would be the application of a legal presumption of equal parenting time. This presumption provides judges with a clear guideline and avoids the dilemma of judges adjudicating the relative amount of time that each parent spends in child caregiving before separation. The fourth stage would be the application of a rebuttable legal presumption against shared parenting in cases where it's established that a child is in need of protection from a parent. Shared parenting would be rebuttable only in cases of established family violence and child abuse. Only with an investigated finding that a child is in need of protection from a parent is a judicial determination of sole custody warranted. Moving on to the other three pillars of this framework. So the first would be a rebuttable legal presumption of equal parenting time. The second pillar of treatment would be comprised of child and family support programs, including divorce education, family mediation, parenting coordination, parallel parenting. Shared parenting as a legal presumption has worked best in those jurisdictions that have provided a universally accessible network of family support services and programs. For example, in Australia, a countrywide network of family relationship centers where family members can get support at each step on the way during their separation and divorce transition. The third pillar of prevention is comprised of a more comprehensive program of co-parenting education and support, includes co-parenting education within the school system and marriage preparation courses and upon divorce. Public education about shared parenting is very important, including models for high conflict couples. And the fourth and final pillar is that of enforcement of legal shared parenting orders, and which enables sanctions to be imposed where there's non-compliance or repeated breaches of co-parenting orders. This addresses parental alienation as well as the broader issue of violence and abuse in family relationships. When it comes to family violence, including parental alienation, children's and parents' safety must always be the primary consideration, and that includes addressing family violence as a criminal matter and child abuse as a child protection issue. And it also includes recognition of parental alienation as a form of child abuse and family violence. Abuse and violence allegations must be fully investigated by child protection authorities and prosecuted via criminal proceedings. So I'd like to end my presentation with a short discussion about a support service that I think would have enormous positive impact for high conflict couples, and that's therapeutic family mediation, focused on the development of shared parenting plans. The uptake of family mediation is actually quite low within the present adversarial framework of child custody determination. If family mediation and therapeutic interventions are going to be effective with a broader range of families, the courts have to allow the space to make this happen. If a presumption of shared parenting is legislated for couples in conflict, the courts can refocus their efforts on the important task of addressing family violence in all its forms. More importantly, with a shared parenting law in place, most conflicted couples will turn to family mediators rather than lawyers for support. Now, therapeutic family mediation is different than traditional mediation because it's more than just dispute resolution. The goal isn't just the settlement of disputed issues. It's a method by which parents can be assisted in formulating an individualized shared parenting plan based on their children's needs. The role of the mediator is also different from that of more traditional mediators. The mediator would assume a more proactive role in facilitating the development of shared parenting plans that address children's core needs. The mediator takes on more of a therapeutic and educative approach, like encouraging ongoing parent-child relationships, keeping children shielded from conflict. Interventions are designed to enhance parental communication and negotiation skills. These are integral to this approach. I have written up this model, I guess, in the British Journal of Family Therapy some years ago. And how am I doing for time? Okay. So, yeah, basically, I'm suggesting that that with a shared parenting law in place, the mediators can move from a very structured dispute resolution kind of model to a more therapeutic approach where they assist parents in the development of a shared parenting plan. So the goals of this form of mediation would be, first of all, to integrate existing knowledge about the effects of divorce on children and parents, and educating parents so they can make informed choices about co-parenting alternatives. A second goal would be maintaining a child focus and integrating a parental responsibility to children's needs approach, focusing on children on the children's unique needs in the family as a guide to mediation. And then thirdly, focusing mediation on the development of co-parenting, shared parenting plans. So there are a whole lot of differences in terms of how to approach mediation before the mediation begins, the beginning phase, the middle, ending, and follow-up phase, which I think I'll just leave for the time being.
We can circulate more information.
Yeah, yes. Yeah. I guess I've been a very strong proponent of mediation as an alternative to kind of traditional adversarial forms of dispute resolution. Relatively few parents are kind of channeled into the mediation approach to resolve their conflicts, because the law is sort of the dominant system that really restricts their options. But if a shared parenting law is in place, it's much more likely, and we know from countries that have established shared parenting as a legal presumption, that the use of mediation and other support services is much more prevalent. And there's just tremendous potential in regard to mediation as a viable alternative in high conflict cases. So I think at this point, in talking about mediation as a kind of viable alternative, and talking about other support services, I'm sort of moving into Natalia's presentation. So I think I'm kind of and Shared Parenting Scotland itself has a broad range of support services, including New Ways for Families program that emphasize a lot of the elements I've mentioned already. So I'd like to turn over the discussion to Natalia, who will describe some interventions from other countries that could be applied to Scotland. And I'm hoping we can follow that up with a discussion on how prepared are the Scottish courts to lead the transition from family law to family support, and how can we work to influence lawmakers and the judiciary to move in that direction. So I'll end at that point.